I'd like to jump straight ahead to His Excellency, Mr. Othman, for some introductory remarks. So over to you. The floor is yours.
May God's peace be upon you. I will speak in Arabic. I'm very pleased to be here. I am very pleased to be here because we consider the UAE as our home. We are one people. We are brothers and sisters. I am very happy with this interaction. I would like to thank our sister Mariam, and I would like to thank everyone for inviting me to be part of this forum. I agreed with my colleague to give me about 5 minutes where I can give you a comprehensive vision and a background info, and then we move to the discussion. Now, of course, my brother spoke of the hybrid legal system in the UAE and the concept of the future, that we will be shaping the future throughout, what to do. But however, before we move to the future, let us really identify what is the status quo of legislations and the regulatory system today. Let me say that the Arab region, of course, most of the Arab states in this region were under the, let's say, the British mandate. However, we realized that it's a bit of a paradox because we all adopted the Latin or the French legal system. Why? Because although we were under the British mandate, of course, it would have been very understandable to adopt the common law or the British legal system. However, why did all these states move to the Latin legal school, or the French common or civil law? And this is the reality today. So this is the first paradox. Let us talk about that first and foremost. This is first. Second, the second point I want to talk about is that our status quo today is that the civil laws that still govern since the 50s of the last century up until our present day have their sources in the French civil law first, as well as the Islamic Sharia. But, of course, there are slight differences from one state to another. Now, let me focus on something very practical, and that is the school of Dr. Razak As-Sannouri really gave a new framework for the Egyptian civil system, moved to Iraq and did the same, and then in Syria moved to Syria and wrote and drafted the civil law, and then to Libya and then to Kuwait. So had he lived long enough, I think he would have drafted all of the civil laws in our Arab states. So even the civil law in the UAE, they were impacted and affected one way or another by Dr. Abdulrazak As-Sannouri. So, of course, there are positive aspects here that all of the Arab states in this region are united one way or another through the provisions, the sources, the contracts, responsibilities. So within the civil law framework, we are united one way or another. However, a third question is, are we ready for the future today, given a civil law that is based on the Islamic Sharia and the French law? And so this is one question. And I think you will ask me about this question, sir. But I think, in my opinion, I think we are in need of a pioneering legislative base. And I invite the United Arab Emirates to lead. And I emphasize this word, to lead. You are leaders in this region because in the legislative arena. Why? Because you are highly qualified. You have become the center of global trade in this region. And thus, any legislative reform in civil law or the Arab civil law, because of course the main structure is one. So I think this launch needs to have its source in the UAE, and you can include reforms, radical reforms. Now, why should we do that in its current form? Why should we have reforms? Let me say that you in the United Arab Emirates, you say that you have adopted a hybrid legal system. You built the DRC, which is the international, DFC, the international financial, but you have let go of the international system and you moved to the common law. You moved to the common law, you adopted the common law. So my question is, Should we stay as we are now, going in parallel with what is happening and widening the scope of applying the common law in the UAE, and we keep the other provisions as they are? In my opinion, I will put forth this idea. Let us work together. Let us work together. Let us work in parallel. And let us include serious reforms. And I do have my ideas on that. And I will share with you my research on this. I've conducted an academic research, and I'll provide you with copies. So let us work together in parallel to conduct real reforms inside the civil law, on the civil law, and then we can widen the scope of implementation of common law. So how can we amend this civil law? First, I suggest minimize the gaps between what is civil on the one hand and commercial on the other hand. We suffer from the civil law because we suffer from what we call civil transactions and commercial transactions, knowing that they are one and the same. So let us minimize those gaps. Let us minimize those differences between the civil law and the commercial law. Here I'm talking about the civil law in itself. This is first. And second, minimize the gap and bridge the gap between the common law and of course, and the common law and the private law. So let us minimize and bridge the gap between private law and common law. But how do we do that? For example, the civil law is the administrative law. For example, in France, even the France, which is the mother country, let us say, of the Latin law, and I have conducted an academic research with another academician where I spoke of a progressive degradation of the civil law and the administrative law, because now civil law and administrative laws, both of them are becoming one and the same. We do not really see big differences. So are there specificities for what we call administrative disputes and civil disputes? So we need to unify the amendments. I repeat, the amendments should be based on first bridging the gap between civil and commercial laws, as well as civil and administrative laws specifically. And third, I suggest that we need to conduct research based on data, research centered on data, where we will look at integrating civil laws with economy, for example, as well as politics, civil law, including other considerations, other fields, other sectors. That is why, if there were a workshop in the UAE, we can work together, we can include amendments, big amendments, and then we move towards widening the scope of common law in the UAE. I'll suffice myself with that, and I'm more than willing to answer your questions. I'm sorry if I took more than my allotted time.
Perfect. Thank you so much for those interventions, Your Excellency. Really, really insightful. And I'm going to come back to you to ask you a question about that historical point that you raised in just a minute. But maybe I'll go back to Minister Al Nuaimi first. So I wanted to dive in on one of the points that you raised in your presentation. Could you expand a little bit on what you see as the benefits of a common law approach, and maybe give some examples of how you've integrated that into the UAE's legal system? So there was that one slide there where you talked about FDI in particular. So I'd be really interested to hear a little bit of a deeper dive perspective on those issues.
Well, the UAE, as I've clearly mentioned, is a primarily a common law based system. But in order for us but we did incorporate elements from the common law system traditions in our civil regulations and court practices. So a good example of the courts would be talking about the FDI, the IFC and ADGM court system, which 100% apply the common law legal system. From a legislative perspective, a good example would be the arbitration law. So while talking about the arbitration law and taking into consideration the unilateral model law, we did extract and utilize the best practice of it into our arbitration regulation, which was recently amended. A good example would it also be the company regulations. So the UAE did consider to introduce a corporate governance rule influenced by the common law principle into our civil regulation related to the company's law. The bankruptcy also, when we talk about the bankruptcy regulations, there is a very much a clear reform which incorporate restructuring mechanism exactly like the Chapter 11 regulation, which was a very clear sort of process to be implemented in such cases.
Thank you for those responses. And I think what's really interesting about the DIFC's jurisdiction in particular is this idea of the opt-in jurisdiction, right? So businesses can choose the system that is most suitable for their commercial interests or for their legal situation. So that's a really interesting perspective. Thank you for that. Mr. Othman, I'm going to turn to you now. And so in your introductory remarks, you mentioned a little bit about the history of the civil law system in the Arab world. But I wanted to touch on a little bit about the Kurdistan region in particular. In your view, why do you think the Kurdistan region adopted this civil law-based system instead of the common law approach? Like you said, there is some historical context here given the British mandate, but eventually the Kurdistan region settled on a civil law approach, at least historically. So I'd love to hear your views on why that happened.
Of course, we consider Kurdistan as part of federal Iraq, and thus we are under those laws and regulations in the region, and thus we followed the Latin school and the civil law, generally speaking. However, if you ask me, in the Kurdistan province, have we started moving away from the Latin school with regards to letting go of the civil law? I say yes, we are following this track, and I'll give you an example. When we look at the oil and gas legislation of 2007, we took the first step in letting go of using the civil law as the general legislation for contracting. And we depended on common law. Common law now it supersedes, and it is the law that we depend on with regards to oil and gas. And this brought us millions and billions of dollars to invest in the province of Kurdistan, and thus the benefit of adopting a common law. Of course, it's very flexible, and I can talk about other areas if you have a question similar to that. However, let me say something. Why has the Arab region adopted the Latin school? Can I talk about that? Allow me. Now, of course, in my opinion, of course, we should have adopted, or maybe it would have been more logical to adopt the common law. But why did we move away from that? The Latin law is easy. It's drafted in a very easy way. So what did we do? What we did was take that written law, translate it, and we automatically found ourselves with a legal system. However, the civil law does not have a clear framework. Thus, it was difficult to adopt that. And second, the Arab states in this region early on were still young states from a legal perspective, and thus we did not have really all those needed legal aspects. That is why we moved towards that direction, and thus we needed the help of Dr. Razak. However, and let me tell you that I have an opinion in that. I say that what we did was because of our dependence on the Islamic Sharia. We held fast and we really were committed to the Islamic Sharia. So it is true that the source is the French law. However, the Islamic law is there when it comes to financial transactions and social transactions. So the integration of the Islamic Sharia and the French system helped this region adopt the Latin system. I see and I think that the future is moving towards common law. And I think that this is the future. We are going to move towards common law. Why? I have answers. If you would like me to put them forth, I do have the answers.
Perfect. Thank you so much for that intervention. I think what's really, really interesting, a point that you've raised there, is this idea that civil law has this inherent sense of clarity because of the fixed set of statutory rules or prescriptions. And if I could share a very, very brief anecdote from some of the work that we do at the World Bank, we see this in, for example, the data protection instance, for example, right, where countries around the world are adopting models of regulation that look very similar to the GDPR. But I think you raised a really important point, which is when you're looking to incorporate statutory law, you need to think about your local context. How do you adapt that for your own political economy, for the institutional capacity that you have within your jurisdiction? So that's a really interesting point. Thank you for that. I'm going to turn back now to Minister Al Nuaimi. So a theme that's been running through this discussion is how legal systems can adapt in the face of ever-increasing globalization and cross-border trade. So given this global economic integration, what do you think are the advantages of this hybrid legal model when enhancing sort of cross-border legal cooperation?
Well, I did highlight it earlier. It gives much more flexibility to the end user of such regulations to consider either to have a base on the mainland or on the free zone area. Just to go back to His Excellency comments earlier, we in the UAE are giving a very much a flexibility to the investor to choose between. It is the reason actually behind the UAE is opening up very much to the common law system. It is a demand-driven. So we continuously follow the investor challenges and concern on the mainland, and it turned out that the international investors are very much happy and feel much more comfortable with the common law rather than the civil law. Therefore, the government took an initiatives, and probably Maryam may correct me, or the legal experts may correct me in the audience. This is the last time when we did amend our constitution back in 2004. The leadership and the government have seen the importance of amending the constitution to cater for more investment into the region. Going to the next 50 years, the UAE is very much focusing into moving away from dependence of oil to a completely economic and investment attractiveness to the country. So taken into all of those considerations, I think the UAE will continuously look after the investor, and we would think that we would always be the preference for those investors to have a base in the UAE, and the government does look after them for all challenges and concern.
Fantastic. Thank you so much. I think that point that you've raised, looking forward, not just the next 5-10 years, but the next 50 years, I think that's really important when we think about legal reform, right? You have to amend the Constitution in order to create this hybrid legal system. Thinking at the beginning, what are the upfront costs? What do we need to do now to make our legal system future-proof for the next 50 years? And I think that's something we can all learn from, given, for example, the rise of artificial intelligence. That was a theme throughout some of the opening remarks, trying to future-proof our legal systems for these new changes. I see that we're running quite short on time, so maybe I'm going to pass it back to Mr. Othman for just one final, very, very brief remark, 1 minute or less. Given what we've heard about some of the UAE's experiences with hybrid legal systems, do you think there's any lessons learned that you could apply to the Kurdistan context, or that you think the audience could take back home to their own jurisdictions?
In my opinion, why will we move towards the common law in the future? And why should we join that movement? First, most of the international trade contracts are in English. This is first. Second, most of the arbitration centers adopt common law. The American influence and all the dealings with the dollar, especially, or all of the aforementioned. So all of that really make it necessary for us to join that movement, and it is more appropriate for us. It's better for us. Now I go back to your question: how can we guarantee a safe legal system that will go hand in hand with all of the progress? I think it's a twofold answer. First, we need to have an effective judicial system, and we need to give the role of drafting laws and legislations to the justice itself, to the judicial system itself, because otherwise we will not be able to really join that movement, because we always see progress. Every minute there is a new progress. So we need to give it or leave it up to the judicial system, because given the current law, we feel that there is that the judicial system is a bit limited. So how can we guarantee and make sure that the future is a safe one? We need to widen the scope and the mandate of the judicial system that will allow the judicial system to go hand in hand with all the progress and all the developments that we see. This is first. Second, and to me that's a challenge with regards to the adoption of the common law, to be more open and to be able to implement and comply with the common law. I think a challenge is the societal and cultural values. We need to focus on that. We need to focus on those two matters. First, we give the judicial system a bigger role in drafting regulations and laws. This is first. And second, how can we preserve our cultural and societal values? So if we are able to strike a good balance between the two, we will be able to join that movement. We will not be left behind, and we will not be left behind legally speaking. Thank you. I will speak in Arabic until, Your Excellency the Minister, until we agree on the implementation of common law in all of the countries. We in the Emirates, we say that we welcome everyone. We have started complying with the common law. We have the civil law, and we are welcoming all investors until we all agree on adopting the common law. I invite you very quickly to adopt the Emirati common law so no one is left behind. We should not take the risk, because I think you are able and skilled and qualified to lead the legislative reform movement in the Arab region, and we are at your service. We are under your disposal, and we in the Kurdistan province have excellent experiences. I personally am looking into that legal system. We have huge contracts that we have signed. We are at your service and at the service of that movement.
Time for our panel, but I'd like you to all join me in giving a big round of applause to our two esteemed panelists. Thank you so much.